Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics. And today on my podcast, we're going to talk about a topic that I know we've talked about in the past on the podcast, right to farm laws and scare guns. So I believe back in 2015, I posted a blog post on it. I didn't look back in the past episodes to see exactly what year I covered it in, but I think it was right around the same time we covered it on this podcast as well. And I'll post links to this in the show notes as well, as I usually do. I wrote this post covering about a town in Wisconsin that had passed a scare gun ordinance, and a family that farmed in that community. That post involved a 2013 challenge to the town scare gun ordinance that required anyone seeking to use a scare gun to apply for a permit from the city and meet a minimum set of conditions. The previous post kind of goes into that. In 2017, the town changed the ordinance to ban the use of scare guns inside the town with no exceptions. The Kleins, the family in question, also challenged this ordinance. They challenged the 2013 ordinance. They challenged the 2015 ordinance as well for a violation of the state's right to farm law. The court dismissed that lawsuit on some procedural grounds that we'll talk about, and the Court of Appeals affirmed that decision. We'll talk about all that here in a minute. Let's give a little bit of background on this. The family in question had been using scare guns as a part of their agricultural operations since 1962. Complaints from neighbors had led the town to develop this 2013 ordinance, which required a permit before using a scare gun. The family in question applied for the permit and received a permit to operate a scare gun, but were later cited for violations of the permit. The family unsuccessfully challenged the permit in 2013. You can learn more by clicking on some of the stuff in the show notes to look at that. The town then enacted a new ordinance in 2017, eliminating the use of scare guns for any reasons. The family continued to use their scare gun and were cited for continued violations of the 2017 ordinance. Before we get started, I realize I forgot to talk about what a scare gun is. It's some sort of propane type cannon, could be something else used to create loud noise to scare birds away from crops. They are typically used in areas where we might see a lot of bird damage to growing crops. With that said, now let's go back to what the Kleins were looking at when they moved the case forward. The family brought an action seeking a declaratory judgment against the town. In this action, the family urged that the scare gun ordinance was an unconstitutional taking, was arbitrary and capricious, and was preempted by the state's right to farm law, and that the family had a vested right to use scare guns. The trial court dismissed the complaint, and the family appealed the decision, but later voluntarily withdrew the appeal and also pled guilty to the ordinance violations for the violations of the 2017 ordinance. Then the family started a new action that alleged the original four claims all over again. So those four claims we just talked about that they voluntarily withdrew the appeal on, they started that process all over again. The town moved to dismiss the claims, and the trial court agreed. The family then appealed that dismissal. So let's move on to what the Court of Appeals decided. Before we get into that decision, we need to discuss a legal restriction on lawsuits. Typically, courts will not allow lawsuits that are collateral challenges to prior lawsuits. A collateral lawsuit or a collateral challenge is attacking a previous judgment by bringing a new case. For example, this is the best example we can think about this. In a divorce case, Tony is ordered to pay child support to Carol. Tony potentially would be barred later for bringing a lawsuit to demonstrate he's not the the father of the child. He should have brought that lawsuit originally earlier, not later. That's a collateral attack. On limited grounds such as fraud or irregularities, typically, those will allow a collateral challenge to be allowed. In most other cases, it's not. In the appeal before before the court, the town argues that basically this litigation, this new lawsuit, is barred because of the rule against collateral tax. The court agrees that this present lawsuit is barred as a collateral attack. The lawsuit in question involves the same 2017 ordinance and the same legal theories used in the original declaratory judgment suit that the family in question, later voluntarily dismissed. The court disagrees with the family that the voluntary dismissal allowed them to revive the lawsuit. That wasn't what happened here. The court looked at it and said, no, there's nothing in that dismissal that would allow you to bring that up. That may be a case in some cases, but not in this case. The court also barred the family in question's claims under the doctrine of claim preclusion. Claim preclusion bars relitigation of the same claims with the same parties, the same subject matter, and the same claims if there is a final judgment in the original lawsuit. In Wisconsin, the courts have determined a 3-part test to determine preclusion. The 3 parts in question are identity of the parties or their privities in the prior and present lawsuits, the identity of the causes of action in the 2 lawsuits, and a final judgment on the merits in a court of competent jurisdiction. The court agrees that the town met the first 2 elements in the case. We have the same 2 parties in the 2 cases and the exact causes of action in the 2 cases. The court rejected the family's argument that the dismissal of the first lawsuit was not a final judgment. The family argued that their original attorney failed to develop a record in the original lawsuit. The court disagrees with this, pointing out that the dismissal had happened while the case was on appeal. The circuit court had developed a lengthy decision in the original matter, and the dismissal had been on the merits, leaving no opportunity to refile the original claim. For those reasons, the court affirmed the lower court's decision in the lawsuit. So why do you care about this? There's an old adage, if first you don't succeed, well, try again. That's not always how it works with lawsuits. As the court highlights, you typically get 1 bite at the apple. In some of these cases, you don't get multiple bites. The Kleins, the family in question, were attempting to have a 3rd day in court to bring the same claims, which had not worked in the past. This case highlights that the fact that we typically get 1 shot on claims, and we frequently have to live with the outcomes, even if they're not in our favor. This case also highlights another issue. The family had historically used scare guns on their property. Scare guns have a legitimate purpose in ag operations. Still, from the facts presented, the family in question may have misused this equipment and really were not willing to modify or do anything with their existing use to avoid conflicts with neighbors. The neighbors successfully got the zoning ordinances changed to prevent the use of scare guns because of this. In several cases, this kind of zoning change would fall under the protection of right to farm law, and the operator may have to change. In several cases, these kind of zoning changes would fall outside the protections of the right to farm law, and the operator may have to change practices to meet the new zoning requirements. So these are things we need to think about as, we're looking at these, right to farm laws, or not really right to farm laws, at the zoning ordinances to see, do they fall under it? Some states may allow this, some states may not. Wisconsin did not. Other states may in limited cases. So it's something you need to think about depending on what state you're living in. So thank you for listening. If you have any questions, please email me at lgoering@umd.edu, or you can tweet me, send me a message on Twitter. You can send me a message on Instagram, all at AgLawPaul. Thank you again for listening, and enjoy the rest of your day.